Did you know that sending a simple email with a child's name to a server in the US without permission could technically be a criminal offense from day one? It's not just a fine, it's a compliance trap, just waiting to happen. Welcome to IT Playground Podcast, where technology meets innovation. Join us as we explore the latest trends, insights, and expert opinions on all things IT. Today, we are doing a serious deep dive into something that I know sounds incredibly dry on paper, the POPIA compliance guide for cross-border data transfers. But it's actually a minefield for literally every business owner I know. And look, I know what you're thinking, compliance, again. But check the calendar. It is Wednesday, January 28, 2026. The landscape has shifted under our feet while we were busy looking at AI.
It absolutely has. The
Lord.
days of, pleading ignorance or saying, I didn't know the server was in Oregon, they're long gone. The grace periods are over. The regulator has teeth now.
Exactly. So our mission today is to demystify Section 57, explain why using the cloud is way more complex than just, uploading a file and, frankly, keep you out of jail or from paying massive fines. We are going to unpack the gotchas that even the most compliant businesses are missing right now. So let's get into it. Looking at the source material, at the regulations as they stand here in early 2026, what was the one thing that made you go, okay, that is actually scary?
Without a doubt, it's the prior authorization trap. It's nestled in Section 57 of POPIA. And the scary part is that you can be following every other rule perfectly. You can have your information officer, the best firewalls, done your training, but you can still trip over this one specific wire and face criminal liability.
So let's unpack that, because usually compliance is about how you handle data, right?
Yeah.
Encrypting it, not losing it. This sounds like it's about asking permission to handle it at all.
Precisely. That's a great way to put it. Essentially, Section 57 says you need written permission from the Information Regulator before, and that's the key word, before you transfer specific types of data to a country that doesn't have adequate data protection laws.
Okay, specific types of data. I assume we aren't talking about a generic client list with just names and emails, because if every email needed permission, the economy would just grind to a halt.
Right. No. General data is usually fine if you have the right contracts in place. We're talking about special personal information. This is the really sensitive stuff. So religious beliefs, health data, biometric data, trade union membership, criminal records.
Right, trade union membership, that's in the same category as biometrics.
It is, yeah. It's considered highly sensitive because of the potential for discrimination. But the big one, the one that catches everyone off guard, especially in education and medical, is children's personal information.
Right. And if you think about it, in 2026, practically every school, every pediatric practice, even a local sports club handles children's data.
Exactly. And here's the trap. As of right now, early 2026, the regulator still hasn't issued a definitive white list of adequate countries. They haven't come out and said, the U.S. is fine. Go ahead.
Exactly.
So if you send health data or a child's name to a server in the United States, which, lacks a single federal privacy law deemed adequate, without applying for that authorization first, you are technically committing an offense.
That is wild. I want to make sure I get the mechanics here. So let's say I'm a school administrator. I sign up for a cool new educational app hosted in California. Great tool, helps the kids with math. I upload a student list to set up their accounts. I'm just doing my job, but technically I've crossed a legal line because I didn't ask the regulator first.
Correct. That is the Section 57 trap in a nutshell. Many companies transfer this data thinking they're safe because they have a standard contract. They think, oh, I signed the terms of service, I'm good. But for special personal information and children's data going to these non-adequate countries, the contract isn't enough. The law is very specific. You're supposed to pause, file an application, and wait.
Which creates a massive friction point. I can't imagine many startups or schools are actually pausing to write to the regulator. It's so counterintuitive to how the modern web works, isn't it?
They aren't pausing. And that's why it's the biggest risk in this whole deep dive. It's just widespread non-compliance, simply because it's inconvenient or people just don't know. But ignorance isn't a defense anymore.
Okay, that is a massive red flag right out of the gate. So, if the U.S. is a problem area, let's look at the map. Geography seems to matter a lot more now. Where can we send data safely in 2026? Who is on the safe list?
Well, since we don't have that official white list, we have to rely on a sort of legal consensus about countries with laws that are substantially similar to POPIA. The benchmark is almost always GDPR.
So Europe is generally the safe harbor.
Yes. The UK, even post-Brexit, is safe. They kept the high standards. EU members like Germany, France, Ireland, those are the gold standards. If your data center is in Frankfurt, you're usually starting from a safe place. closer to home, Mauritius is often used as a safe African hub, and then you have New Zealand and Canada.
Okay, so if my server is in Frankfurt or Dublin, I can breathe a little easier.
You can, yeah, but you still need to document why you believe it's safe. But let's talk about the problem areas, because that's where most of the tech giants operate. The USA, Australia, and India.
We already touched on the US. It's huge for tech, Microsoft, AWS, Google, almost everything runs through there. But you're saying it's not automatically safe? I mean, it's the US.
I know, but its privacy law is the Wild West compared to Europe or South Africa.
Sure.
They don't have one single federal privacy law like we do. It's a patchwork. You've got HIPAA for health, CCPA for California, but nothing that covers everyone federally. So you can't rely on their government to protect your data. You have to ensure the provider has standard contractual clauses, or SCCs, in place.
Standard contractual clauses. That sounds like a lot of legal jargon.
It is, but it's so important. You need a data processing agreement that references POPIA or GDPR standards. You're basically building a little legal wall around your data because the country's laws won't.
That makes sense. It's like saying the country's laws aren't enough, so our private contract has to do all the heavy lifting. What about Australia?
They're getting there. They're finalizing reforms to align with global standards. It's sort of a mixed high alignment situation, but they're not officially adequate. So again, you need a written agreement.
And India. A lot of South African companies have back offices there.
India is strongly improving. With a full enforcement of their DPDP Act in 2025 and 2026, they're much closer to POPIA. It's a huge leap forward. But, and I can't stress this enough, we aren't there yet. You still need a data transfer agreement to be 100% compliant.
This really just highlights that you can't throw data into the cloud and forget about it. The cloud has coordinates. It lives on a hard drive somewhere. Which brings us to the cloud misconception.
Oh, this is a classic. The out of sight, out of mind fallacy.
Right. I think a lot of people hear hosting and they think storage, like a digital filing cabinet. But POPIA sees it differently, doesn't it?
Very differently. POPIA defines processing in incredibly broad terms. It includes consulting the data, updating it, using it for analytics. It's active, not passive.
So let's play out a scenario. If I have a sister branch in London and they just open a file to look at a client's address on a server that's physically here in South Africa, has a transfer happened?
If they access it, yes, 100%. If an overseas branch even looks at the data, it counts as a cross-border transfer. It's not just about where the hard drive sits, it's about where the eyes are. The moment those eyes in London see the data, it has technically traveled there.
That is a crucial distinction. It means remote work is a compliance nightmare if you aren't careful. If your admin is on holiday in Bali and logs in to check the CRM, boom, you've just transferred data to Indonesia.
Exactly. And you better hope you're covered for that.
Now, speaking of the cloud, let's talk about the tool almost everyone uses, Gmail. The sources had a very stern warning about free Gmail. And I have to be honest, this one probably affects half the small businesses listening right now.
This is probably the most common compliance failure I see. Plumbers, consultants, even some lawyers running their business on a generic @gmail.com address. If that is you, you are generally not PPIA compliant.
I can hear the panic setting in. Why? It's Google. Isn't Google secure?
It's not about security. It's about legality. There's a huge difference. With the free version, you are the product, not the customer. You do not have a formal legal contract with Google. No data processing amendment. You're trusting a consumer service with business data.
So there's no legal hook holding them accountable to South African laws.
Exactly. You have no shield. You're naked in the eyes of the law.
So what's the fix? Is it just buying Google Workspace?
That's step one. But here's the detail that trips people up, and this is really important. Buying it isn't enough. You have to perform a manual act.
A manual act what? Like physically signing something?
Digitally, yes.
Yeah.
Just paying the invoice doesn't activate the legal protection. You have to go into the add-in console, find legal and compliance, and actually click Review and Accept on the Cloud Data Processing Addendum, the CDPA.
That's so specific. So if you've been paying for years but never click that button.
You might not be covered. You're paying for the tool, but you haven't activated the business protection. That click provides what we call the Section 72 shield. It's what saves you if the regulator asks, how are you protecting this data?
It's amazing how a single click can be the difference. And the sources also mention verifying data regions in there too.
Yes. If you have the option, and Workspace often allows this, choose Europe as your data region. Don't leave it on global or US. Europe is your safest bet. And of course, appoint an information officer.
Okay, so we've covered the what and the where. Now let's talk about the what if. What happens when things go wrong? And specifically, this onward transfer rule.
It's actually the opposite of passing the buck. It stops you from doing that. The rule means you are responsible for where your recipient sends the data next.
The chain of liability.
Correct. Let's say you host your data with a provider in Germany. You think, great, Germany is safe. But that German provider backs up their servers to a data center in a country with no privacy laws.
Who's in trouble? The German company.
You are. You are liable in South Africa because you are the responsible party. The German company is just the operator. You have to ensure that anyone you give data to is bound by rules that prevent them from sending it somewhere unsafe.
That is a heavy burden. And if you fail, what are the penalties?
The penalties are severe. Administrative fines can go up to 10 million rands.
10 million rands. That shuts down most businesses.
Easily. It's an insolvency event for an SME. And for serious offenses like willfully ignoring that prior authorization rule, you could face up to 10 years in prison. Plus, individuals can sue you for damages.
Okay, so how do they even find out?
Well, it's not door-to-door checks. It's usually whistleblowers or customer complaints. But the big one now, in 2026, is the new reporting mechanism.
The Security Compromise Reporting Portal.
Yes. As of this year, if you have a data breach on an overseas server, you must report it via this official portal. If you don't, you get fined just for reporting it the wrong way.
So it's a trap. If you report it, you admit the breach. If you don't report it, you commit a crime.
Exactly. And once you report that breach, the first question they ask is, why was the data there and what legal agreement did you have?
So the breach acts as a flare gun that invites the full audit.
Precisely. It exposes your entire compliance posture.
Okay, we have scared everyone sufficiently. Let's pivot to the solution. How do we sleep at night? The sources mention creating a paper trail. What does this actually look like?
This is your defense shield. You need to create a data transfer folder. It can be digital, but it needs to exist.
What goes in it?
First, a simple inventory. A list of your providers. Know where your servers are. Write it down. CRM is in the USA. Email is in Ireland. Payroll is here. You can't protect what you don't know about.
Check. Inventory. What's next?
The legal hook. For each provider, note down why you are allowed to send data there. Is it because of substantially similar law? That's Ireland. Is it a contract? That's the U.S.
And I assume we need the actual contracts.
You do. Download the Data Processing Addendum from Xero, Microsoft, Google. Keep the PDF on file. If the regulator knocks, you want to hand them a document, not scramble to find a web page.
The sources also mentioned a TIA, a Transfer Impact Assessment. That sounds expensive.
It sounds fancy, but it's just a show your work document. It just says, I am sending data to country X. Here is why their laws are sufficient. Here is the risk level.
So, I use Google is not a defense. But a TIA that says we use Google, we signed the CDPA, and we selected European servers is a defense.
Exactly. It proves you applied your mind.
Right. Finally, transparency. We need to tell our customers, don't we?
Absolute transparency is key. Update your privacy policy. The guide gave two options. Option 1 is a general safe clause. It just says, we may transfer your data to countries with similar laws or binding contracts. That works for most businesses.
And option 2?
That's the more transparent clause. You name the specific countries, we send data to the USA and the EU, and you confirm agreements are in place. A good tip here, if you know 100% of your data goes to Ireland, just say Ireland. Transparency builds trust.
So to recap, check for the prior authorization trap, move away from free Gmail and click the button, know where your data lives, and keep a folder with the contract.
That's the roadmap. It's moving from, I think we're safe, to, I can prove we're safe.
It seems like a lot, but compared to 10 million rands, it's a bargain.
Absolutely.
Before we wrap up, what's the one thing you want our listeners to do right now?
I want you to consider this. You might have the contracts in place, but have you actually read the Data Processing Addendum for your cloud provider? If a breach happens tomorrow, do you know specifically which country's laws will apply to that data? It's time to check your digital passport. Don't just file the document, understand it. Because you can outsource the hosting, but you cannot outsource the responsibility.
A scary but necessary thought. It's your data, your responsibility. Thanks for tuning in to IT Playground Podcast. Join us next time for more tech talk, insights, and innovation. Don't forget to subscribe and follow us for more.